Yeah.
Yeah. Well, I'm going to have one more crack, short crack at trying to deal with this evidence point, and then I'll move swiftly on. But I'd like to just have one more crack at it.
Okay.
Can I ask you to turn to page 32 in the core bundle, or the hearing bundle? So this is the appellant's skeleton argument.
Yeah.
Paragraph 50 and 51.
51.
Paragraphs 50 and 51. Now, certainly in the context of these proceedings, and my own friend will correct me if I'm wrong, but it has never been suggested, or the Secretary's position that the invitation was in under the process, the Secretary's process, he shouldn't have been invited for an interview, has never been challenged. That was the respondent's position, that's recorded. And then when you go to the judgment at page 74, paragraph 60, and the last sentence, the claimant accepts or accepted, paragraph 42 of the skeleton argument, that there was no express decision under Article 17. Obviously, I'm going to have to deal with the fatty points later on.
Sorry, can I just catch up?
Well, yes, page 74, paragraph 60. So I had always understood that the position between the parties was agreed that no decision, no express decision under Article 17 had been taken. Claimant's position is you don't need to, the fatty, accept that point. But there was no suggestion that the decision to invite him in for an interview was anything other than a decision to interview him, and that point.
Sorry, decision. I just lost you.
Was anything other than a decision to invite him in for an interview. But the claimant's point is that step, that amounts to a step in the examination process. And the reason this is clear, and I appreciate not just clear, everyone. And the reason this is important is because although reference was made to splitting hairs, as you will see, the Dublin III developed from Dublin II, and as you will see that the reference to or the need for a decision in the context of Article 3, as opposed to simply an examination under Dublin II, that was a deliberate decision to introduce this extra requirement in Article 17 that you don't just take a step in examining it, you have to have a decision under Article, so for the purposes of Article 17. And I'll make that point a bit more clearly when I take you to the relevant case law. But the position in terms of the facts in this case, and one last go through the GSID notes, is that if you now turn to 419, you were taken, and I think you've looked at the interview being booked. And then I think you've looked at the lower down the page, the letter being sent, the loading review pack being completed. This you'll see is the unit, if you look at it, is CCMTCL01. The date is 13th of June 2016. It's always the date underneath that's the relevant date. Mm-hmm. And then you've got, next page, you've got the interview record, 420 being given to the applicant. Then if you turn over to 421, and you can see that the files are placed on hold. You look at the top, 3 entries. And then you have a reference to, and this is the 30th of August, an error having been made, and then if you go
Sorry,
to
I've got a bit lost. Where's the
Big
files on hold? Top of page 42.
421,
Yeah.
and you see flagged hold.
The date is under the entry.
That's right.
Flagged hold 2016, yeah?
Yep.
Okay.
And then you've got the dummy file,
Error.
which is the 30th.
One word error.
Yep.
An entry on the 30th of August.
Yeah, and then if you go to 428, so that's the 30th of August, you have the email on the 1st of September from the asylum team, so
Yes.
the day after the error, informing that she's just about to complete her action in relation to the application's asylum decision. Now that doesn't mean she's about to sign off the decision, it means that she's about to consider the case. But needed to confirm at what stage the case is in TCU before making her final decision. So what this demonstrates is that you have two parallel processes being undertaken, one by the asylum determination and TCU. And when the asylum unit comes to considering the asylum case, it defers to TCU as to whether, and if so, what decision is taken or has been taken for the purposes of Dublin III. Because on the evidence you can see that the person who would have taken a substantive merits decision before that she takes that decision goes to TCU to check, well, what's the Dublin position? And TCU say in the paragraph below that a diary action was missed, and that's a diary action for TCU because May the 16th would have been when the 2 months elapsed, which would have transferred, which from that date onwards, Italy was responsible, subject to any excuse, any reasons Italy might have put forward. And so TCU decides, well, now that Italy is responsible, under Dublin, we can proceed with the transfer to Italy. And the reason this is important is that on any view, Article 17 does refer to discretion. And on any view, the Dublin process requires consideration of the various criteria of and the various articles. And whilst I agree with my learned friend that you don't need to have, in all circumstances, a formal decision coming out at the end of that consideration process, I agree with that. The whole purpose of Dublin is that the criteria and the articles are applied. And those who apply Dublin are TCU. They are the staff. That is the department through which the United Kingdom discharges its obligations under Dublin III. And in terms of the asylum substantive decisions, TCU have no involvement in that at all. But equally, the asylum, if you look at all the entries, all the communications that are sent from the TCU process in the Dublin process, it's all from TCU.
Okay, so.
But Mr. Payne, where does that get us? Because whether it's one bit of that the Home Office or another, all these decisions are made in the name of the Secretary of State. So I'm not quite sure where this goes.
Well, my lady, it goes in relation to whether a decision taken by a department that isn't involved in the Dublin process can be said to be a decision for the purposes of Article 17.
Right, so should we look at how this fits into Article 17?
Absolutely.
That's where you're coming to, is it?
I've been slightly longer than I said.
No, this is where you're. I can now see, I think, outlines of your case. And so we look at Article 17.
Milo, would you mind if we just went through just a few previous articles and then I would turn to Article 17? So, if you could take the authorities bundle, and if you can start at page 3, which is should be the Dublin regs, and you have recital 17. Could you read recitals 17 and 18, please? So you have at 17 the rationale for the derogation that's included or reflected in Article 17, and 18 was just to make clear, I think, the point that my lady made in terms of the nature of the personal interview. So if we then turn to page
let's
6.
just so are you saying that Article 17 has to be read as meaning derogation for the reasons identified in recital 17?
I can't say, I can't go that far, but I can say that recital 17 informs or indicates the purpose, primary purpose of Article 17. And I'll take you to case law, which confirms both that whilst Article 17, in terms of the wording of Article 17, is broad, the object is actually...
Okay, so the decision to examine in Article 17, I now keep on going back to 17, but just so I follow this point, has to be, to come within Article 17, it has to be by way of derogation from Article 3.1, whether that be for the reasons in Article 17, in recital 17, or some other reason.
Yes, that's right.
It can't be, you say, it's not an accidental decision, as it were,
Absolutely.
to examine. It has to be a conscious decision to examine by way of derogation.
Yeah, for the purposes of Article 17, absolutely. Absolutely, because that Article 17 is the article which permits or provides that for that exercise of discretion. But I think the key thing, and I'm going to try not to repeat myself too much on this, is that Article 17 is all about a discretion. So we are in an odd position here where what's being suggested is that the Secretary of State didn't think she was exercising a discretion. The Secretary of State's submissions in front to the court in Fati made it quite clear what her understanding of it was, how she would exercise her discretion. And yet, despite Article 17 being a discretionary clause, what is being said is, well, actually, just by examining, just by taking any step in the examination process, you automatically become responsible. So it is an oddity that something which is meant to be a derogation from the norm, something which is meant to be afford this sort of discretion out. The Secretary is saying, well, actually, you might have thought you weren't exercising this discretion, but in fact, you were. And we would say that, considered in that context, it would be totally inconsistent with Article 17 for member states to be fixed with responsibility for determining cases when they hadn't, as far as they understood it, they hadn't exercised that discretion at all. You will see that throughout Dublin III, there are strict timeframes, there are strict criteria, and when those timeframes or those criteria kick in, then responsibility transfers. So it's not a question of discretion. It is simply, for example, you don't do it in 2 months, member state, the transfers to you. What it doesn't say anywhere in this regulation is you take a step in examining a case, responsibility transfers.
So how does Fati fit in with this?
Well, Fati is actually...
It post-dates the decision.
Absolutely, but my lord, Fati, when we go through it, you will see, well, I hope to demonstrate, it provides no assistance at all. Okay. Now, can we just go to page 6 then?
So, sorry to interrupt, Mr. Payne. So your submission is that whether or not a member state has derogated from Article 17 depends on the member state's subjective intention rather than the member state's objective conduct.
My lady, sorry, did you say objective on both occasions?
I meant to say draw contrast between the subjective intention of the member state and the objective conduct. And as I understand your submission, you're saying whether or not a member state has derogated from Article 3 under Article 17 depends on the member state's subjective state of mind rather than on the member state's objective conduct. Is that right?
Yes.
Okay, let me get a note of that.
How is the claimant to know what the position is?
Precisely the point is that when there has been a subjective exercise of discretion, so in other words, when the Secretary has taken this decision to assume responsibility under Article 17, yeah, the claimant is informed by way of a dropout letter.
Well, but the claimant's never seen a dropout letter.
Well, he has now.
Yeah, but he hadn't.
Yeah.
Yes, but he hadn't at the time when you invited him for interview.
Because we hadn't taken an Article 17 decision.
But how's he to? Oh, so he's not to know because it's
No. I mean, but
subjective.
Well, put it subjective, yes, because the whole point of a discretion, the Secretary submits, the whole point of a discretionary decision is the Secretary has to exercise a discretion to exercise that power. The Secretary never took that decision, never took a decision to exercise the power under Article 17. What the Secretary did was to, and that's outside of the Dublin process because it's the asylum team that did it, was to invite someone in for an interview.
How is the average claimant supposed to parse these letters and go, oh, this is a letter from the asylum team, it's not from the Dublin unit, therefore I should pay no attention to it?
Well, my lady, with respect, the claimant was informed in March that consideration was being given to see whether another country was responsible.
Yeah.
Yes. From the 6th floor, or possibly the 4th floor, I can't remember which, of one building. And then a few weeks later, gets us another letter.
An invitation. But all the letter says is that you're being invited in to discuss your interview. It's not saying the United Kingdom's accepted responsibility for your claim, or that the United Kingdom will decide your claim. When there has been a decision that the claim is going to be examined and by the UK, the applicant is informed by way of a dropout letter. I mean, so your question is, well, how does the applicant know if an Article 17 decision has been taken? Well, the answer is, if one is taken, he will be informed by way of a dropout letter. If no Article 17 decision has been taken, he won't be informed because, as far as the Secretary is concerned, the Dublin process is continuing.
So this was an unlawful examination?
No, there is nothing in Dublin III that prevents steps being taken in the examination process.
Would the claimant have been entitled to say, I'm not coming to this examination because it's out with the Dublin process?
Well,
so
the whole point of the Dublin process is it is a process designed to identify a single member state, responsible for the claim. It says nothing about whether outside of that process, a member state can interview someone in terms of asylum. So I mean, of course, the United Kingdom has the power to interview someone about anything.
So it could have been, the application could have been granted under this process outside Dublin.
Yeah,
and what then?
And if it was granted, this is why I was going to take to page 6. So if you look at, so you've been taken to paragraph 2D in terms of definitions. If you look at 2C, you get the definition of an applicant. So if we'd taken a decision to grant, then that's it. He falls outside of the process. He's no longer an applicant.
Well, if you don't grant it, he remains an applicant.
And he can either at that stage, once I haven't come across that, but at that stage he would have an in-country right of appeal against that decision, which we could certify as clearly unfounded and return him to the other member state.
So a final decision would have been taken one way or the other.
No, because I accept that a refusal wouldn't be a final decision because he would have a statutory right of appeal against it. Does that make sense? Not really.
Well, I understand your argument.
Perhaps I can try and put it this way. My learned friend says, and to a large extent I agree with this, that Dublin III regulations are prescriptive. And so if the Dublin regulations wanted to say, well, actually you take any step in examining the case, responsibility transfers over to you, irrespective of why you do it, that would be, we would submit, that could be easily articulated, as are many of the other sort of fixed transfer issues, time limits, and it doesn't say that. Instead, Article 17 is specifically referred to as a discretionary clause. And it is really the only, sort of, not the only, but the main discretionary clause which is designed, as you'll see, to introduce flexibility outside of the Dublin framework. And to have a discretionary clause, which is meant to provide flexibility, to have it construed in a way that responsibility transfers automatically, even if there was no intention to exercise that discretion, we would submit is entirely inconsistent with the concept of a discretionary clause. Can I just very quickly just touch on Article 3? Oh, a big one. I was going to deal with the other one. So Article 2D, my lady, you referred to the breadth of Article 2D in any examination of decision or ruling. And again, I'm just going to make this point just to sort of illustrate perhaps the importance of approaching this clause with a sort of sense of reality, because as you may appreciate, the decision of the Secretary, which is under challenge here, is the Human Rights Certificate. And what that certificate does is it decides the asylum claim. And it says, we're not looking at that asylum claim because we're returning you somewhere else. So that could easily be construed on a very literal interpretation of this as a ruling in relation to the asylum claim. But of course it's not, because it's the process which is used in order to effect the transfer pursuant to a responsibility decision.
So I haven't quite got that, I'm sorry. I've got the point that you're drawing our attention to where there's a human rights certification in place.
So in order to transfer someone under an asylum seeker under Dublin III, the claim for asylum is refused on the basis that another member state's going to look at it. So on one view, it can then get challenged in the courts. So if the courts were to quash it, you'd have a ruling from the courts in relation to asylum claim. In terms of a decision, you'd have a decision on an asylum claim because the Secretary is refusing it. Of course, none of that would make any sense at all, because that is the very process that.
But the Secretary of State isn't examining the substance of the asylum claim. The Secretary of State is simply saying, I can send you off to a safe third country under Dublin, so that's what I'm going to do.
But it doesn't say examination of the substance of an application. It just says examination of an application. So when an application's made, and if you examine it and say, well, actually, we're going to refuse it on these grounds, which is what the certificate does, on the face of it, it could be argued that that's an Article 2D decision, but it obviously isn't, because that's the process for effecting transfers under Dublin III.
Sorry. Are you saying, how does the definition in 2D fit in with that?
Well, 2D says examination for international mean any examination of, decision or ruling concerning an application for international protection.
Yes.
So, you know,
Except for
the interview, yeah.
Well, except for procedures for determining the state responsible.
Yeah. So in terms of the interview, but ultimately you then end up with a decision to refuse the asylum claim.
Mm-hmm.
But perhaps I've overcomplicated. I think that on reflection, that's a point that perhaps just overcomplicates things. Can I ask you to look at Article 3? And the point that the focus in terms of Article 3.1 was on the fact that the application needs to be examined or shall be examined by a single member state. But of course the next bit of the sentence is equally important in terms of Article 3.1. That is that the member state shall be the one which the criteria set out in Chapter 3 indicates is responsible. And so we say that supports the Secretary of State's position that Dublin III is all about conscious, informed application of the criteria in, or the articles in, the Dublin III regulation, which is inconsistent with a decision taken outside of the Dublin process, fixing the state with responsibility under the process. In terms of Article 2, Article 3.2, that is actually, that clause or that section deals with a situation where there just isn't enough information to work out which member state is responsible. It's not the MSS situation, that's the paragraph below. And that paragraph actually reflects the fact that at the start of a process you can have inadequate information, and as the process carries on and more information becomes available, you can then go back to another member state and see if you can agree responsibility, and if you can't, then ultimately the state that the individual is in, member state, has to assume responsibility for the case, so for the claim. And then the penultimate paragraph on that section, so Article 3, subparagraph 2, and the last paragraph, you again get, and this is the second mandatory aspect of Article 3. It says that if member state can't effect the transfer designated on the basis of the criteria, it shall become the responsible state. So there you can see there's, again, no exercise of discretion. It's simply an action or an event takes place, and then without more, responsibility is transferred. If we can then go to Article 17, please.
Yes, before we do, can I just go back to recital 17?
Yep.
And just look at the syntax. Are you saying that the only derogations are permissible under the regulation are to bring family members, relatives, or family relations? No. You're not?
No. But what I accept that the opening bit, the opening words of the sentence just refer to the ability, states having the ability to derogate from the responsibility criteria. And what I'm seeking to draw from the recital is that the reference to, in particular, on humanitarian and compassionate grounds in order to bring family members, relatives, or other families. Right. So it gives you, we would say that it gives an insight or informs or an indication as to the primary objective of Article 17, that although there is a broad discretion, the objective is really there. And as you'll see, this is...
No, because it says in particular. So it's just giving an example, isn't it, of the circumstances in which the member state may derogate from the responsibility criteria.
Well, my lady, that's not the way it's been construed by the courts, and that's, I wanted just to, for completeness, take you to 17 and then
Okay.
recite 17.
I mean, the question I was asking was a follow-up question from that, which is whether the in particular qualifies the whole of what comes after it, or just on humanitarian and compassionate grounds. In other words, is the derogation simply to bring together family members, relatives, other family relations?
No, it's not. No, I believe
Okay,
that
all right.
it's
So you accept that
it's broader.
it's a broad description of which humanitarian and compassionate grounds is illustration of the sort of factors which should justify,
Yeah,
or require
particular,
justify.
yeah.
That's the way you put it.
That's the way yes, from the recital.
So is there any case in which it was decided that a member state had exceeded the Article 17 discretion by examining an asylum claim in circumstances not covered by the formula to which we were referred in the course of the appellant submissions this morning?
No.
So the formula is repeated in the cases, but my question is there any reasoning explaining that formula? In particular, is there any case which decides that a member state acts outside the discretion conferred by Article 17 if it examines an asylum claim in other circumstances?
No, there isn't a case on that.
Right.
I mean, it's presumably quite unusual to say in which a claimant.
I just can't. I mean, to be honest, that's what I was going to say with respect that a claimant who's benefited from a discretion is unlikely to be challenging the discretion, and the member state who's exercised the discretion is unlikely to be challenging its own exercise of discretion.
Well, that's very interesting, but you were suggesting that the authorities helped us on this, and that's why I asked the question.
Well, I was going to take you to the authorities, and because what the authorities say.
Let's go to them, shall we? If now's the time to do it.
Let's go to. We will.
I like keeping quite tidy notes, and my current heading is Article 17.
Absolutely, and I was going to just
where we are?
yes, and I was going to go deal with Article 17.
Sorry to be a bit picky,
It's
but
all
it
right,
just helps me.
It's my fault for interrupting your note. Anyway, Article 17.
Right.
The case. Oh, you want to take the lady's point, which is you go through Article 17 first, and then go.
So paragraph 1, Article 17 says, and the bits I would emphasise are by way of derogation. So that's the first relevant factor. From Article 3, each member state may decide. That's the second relevant factor. Examine an application for international protection lodged with it by a third country national or stateless person, even if such an examination is not its responsibility. So even if such an examination is the third point. So we say, what that means is that a decision for the purposes or pursuant to this paragraph is a decision taken by way of derogation to Article 3.
To examine, etc.
Yep. Even if, the examination is in fact the responsibility of another member state.
So are you saying that in order for there to be such a decision, the member state has to say, I have decided by way of derogation from Article 3 to examine this application, even though I'm not responsible for it under the Dublin criteria?
No, what I'm saying though is that you don't need a formal decision to that effect.
Right.
But you need evidence, or the Secretary of State needs to take a decision that reflects consideration and exercise of the discretion under Article 17.
Well, I'm not quite sure how that differs from the formulation I put to you.
Well, because if for example, there's a decision taken that because the situation in Italy breaches Article 3, the UK is going to accept responsibility for determining the claim for asylum. Mm-hmm. Yeah, that's not a formal decision, or that's the rationale for undertaking the examination. That would reflect, I would submit, an exercise of discretion under Article 17. By contrast, if you just say, well, I'm going to invite someone who's not at all involved in the Dublin process, just sends a letter off to invite someone for an interview, then that decision, which has no connection to or consideration of Article 17, cannot be said to be a decision for the purposes of Article 17.
And the claimant isn't to know any of this. And he might foolishly believe that they were the same departments because they came from the same building, albeit from different floors. The two decisions.
But I think perhaps we're back to the point, which is that all he was sent was an invitation to come in to discuss his interview. There was he wasn't told, we've accepted responsibility for your asylum claim. And in terms of the way the UK, United Kingdom, approaches the requirements under Article 4 in Dublin to notify applicants as to the outcome, and I'm afraid I'm repeating myself, but if the UK has taken this type of decision, the applicant is informed of that.
Has that happened? Have there been cases in which a decision has been taken under Article 17 by way of derogation from Article 3?
Yeah. Yeah.
And on what grounds?
Well, I mean,
on humanitarian grounds.
Yeah. Okay.
And it says, what do the standard form letters say? We haven't got one, I suppose.
But it just says that there's been a decision to, like this letter, like the letter you haven't read. It's just been a decision to drop for your application to drop out of the Dublin process, and your claim for asylum will be determined in the UK.
But how does the procedure which the Secretary of State has decided to adopt inform our consideration of whether or not criteria in Article 17(1) are met?
Because the procedure the Secretary has adopted reflects its approach, or her approach, to deciding to apply Article 17.
Well, that's just circular. All right, well, that's your answer anyway. Okay.
Well, with respect, because Article 17 is discretionary and not a sort of a mandatory outcome by reason of a specific action taken under the Dublin process, the Secretary of State, we would submit, is entitled to adopt a process that reflects the exercise of discretion. And so, where the decisions reflecting the exercise of discretion haven't been taken, the Secretary of State would invite the court to conclude that no decision under Article 17 has been taken for the purposes or pursuant to Article 17.
What's the practical difference? If the application had been granted in this case, it would be valid. It would be a valid grant
Of asylum?
Yes.
Yeah.
So that would be a derogation, wouldn't it, from the Dublin process?
If it had been granted, well, we'll go to FATI, but effectively it would be a decision as in FATI where there had been no express decision in relation to responsibility. So in FATI, you have the decision taken, well, we'll go to it, but you have the decision taken, but with no express decision as to on what basis responsibility was accepted.
Right. Have you finished talking?
Yep.
Taking us through the 17.
So
Are we now going to go to the cases, you said?
Yep. And in terms of 17, just the next paragraph is key because it's the pursuant to this paragraph, and without, if there wasn't, that phrase would be entirely otiose if it didn't mean taking it.
Well, with that, obviously, we honed in on that when
but
the speaker was addressing us this morning. What does it mean? You say it supports your point that this is, as it were, about a specific type of derogation.
It's about an exercise of discretion. With the rest of it, although my own friend referred to other things, but the other aspects are consequences that flow from expiry of time limits, those sort of things. This clause, and it's pursuant to this paragraph, i.e. an exercise of discretion for the purposes of Article 17.
I think I might have misunderstood this the first time around. The words pursuant to this paragraph on your case hook back to the previous to Article 17 numbered number 1, so the previous paragraph in ordinary language, do they, which talk about may decide?
Absolutely, and this is all the 3 paragraphs are all paragraph
Connect,
1.
they're all paragraph 1. So this paragraph means paragraph 1, which actually has 3 paragraphs in it.
Absolutely.
Okay, thank you.
Right.
Okay, so let's go to, can we go to page 130, and that's the case of Fatty. And I'm just going to take you to the Advocate General's opinion, because as part of the analysis in terms of Article 17.
We established, didn't we, that the AG's opinion was not accepted? Is that right?
I disagree with that. So, but I would deal with that. I would deal with that later.
I should have known better than to this. Okay, Mr. Payne, I'm teasing you. Where do we go to?
I beg your pardon, I meant to ask you actually to turn to 128.
Okay.
So the starting point, and this is the same as this applies both to the AG and the court's decision, is that if you could just read paragraph 23 to yourself, you will see that any comments in relation to Article 17 are obiter. Because the focus of the question is on Article 3, not on Article 17. But in terms of, and you will see that the court doesn't deal with Article 17, save for, it considers Article 17 by reference or in construing Article 3, but there's no standalone consideration by the court of Article 17. Now, if you look at the Advocate General's analysis, if you could turn to paragraph 25, and if you could read to yourselves paragraph 25 and the first 6 lines of paragraph 26.
Right, so the Advocate General says it can be activated for considerations of any kind, and in certain circumstances, like NS Afghanistan, an obligation can arise out of Article 17, even though in most cases it's a discretion, if there are, as it were, human rights considerations that push a member state in favour of accepting responsibility, even though it's not responsible under the criteria.
Yeah, and obviously, my lady, I would emphasise his comment that its use has essentially been advocated on humanitarian grounds and as a safeguard against the shortcomings of the Dublin system. We would say that's entirely consistent with the need for an exercise of discretion.
Yeah, but he's already, if it is a he, I don't know whether it's a he or she has already said it can be activated for considerations of any kind, and there's a reference there to footnote 9.
Halaf, isn't it?
That's Halaf.
Yeah. And then if I could ask you to look at paragraph 28, please. And if you could read paragraph 28 to yourselves, please. And then, so you can see here that the development in Dublin III is to go from simply saying examine, which would be more consistent with simply saying you take a step, you're responsible to, may decide to examine. And obviously, on one view, anytime you decide to take any step, like send a letter, you are taking a decision to initiate or start the process. But we would say that the inclusion of the requirement for there to be a discretionary decision pursuant to paragraph 17 involves a much wider assessment than simply taking an act in the process of examining the claim as part. And this is consistent, we were to make with paragraph 29 of the Advocate General's analysis. I'm going to come back to 30 later on, but
so those are all considerations, if we just go on to paragraph 30, that led the Advocate General to express the opinion that Article 17.1 requires a member state relying on 17.1 to adopt a formal decision to that effect, and that wasn't adopted by the court. Is that right?
That's right, and it wasn't rejected by the court.
I see.
But even if it was rejected, in terms of the conclusion that the Advocate General drew from the points we referred to above, we would submit that the points referred to above, which we're relying on not for the purpose of reaching the same conclusion as the Advocate General, but we are saying those factors he identifies, namely the fact that the Dublin III process builds on, develops the Dublin II process, and the fact that in order to avoid a multitude of examination procedures, which would render the system inefficient, the only way of achieving that is where you have a decision taken by a member state for the purposes of Article 17, because the member state who's exercised the discretion knows it's exercised the discretion, and that brings to an end, or may bring to an end, the Dublin process. Now, the reason why this is an important point to bear in mind, the fact that there are a multitude of asylum procedures, is that in some procedures, for example Germany, as we'll see, when you apply for asylum you are interviewed. And that has never been said to prevent the Dublin process continuing or proceeding.
Is there any decision of the CJU to that effect?
I'm going to take you to it.
Right.
I'm afraid, Mally, because otherwise you will tell me off when we get there. It's not a decision that deals with a contention. It's not argued in that case that by undertaking an asylum interview, Germany became the member state, no responsible member state. But the factual context of the decision was that Germany had interviewed an applicant, and no one suggested that the fact of interviewing the applicant meant that Germany was the responsible member state.
Right.
What's the name of that case?
Can I just take you to RSM? It's
If you,
called,
only if it's convenient to you now. I
Yep.
just wanted to note it
no,
now, so I know when I
absolutely.
come back
It's
to
very
my
difficult
notes.
to pronounce, but it's called Mengistiab.
So that's the one we looked at this morning.
Yeah, and I was gonna just take you to that as well. But if we could go to RSM, which is at the first page is at 321. And I was going to, if I can just then firstly deal with the Menga statements. If you can go to page 335. And you can see at paragraph 42. In the even more recent Mengesteb case. And then if you could just read paragraphs 42 and 43 to yourself, please.
Yep.
And then if you then turn to Mengestab, and that is that. Turn to page 214.
This is tab 6.
My lord, yes. So there you have the date when Mr. Mengestab was heard by the office, at paragraph 31. And then you have at paragraph 34 the Dublin transfer decision.
Yes.
And then this, you remember, is the case where the transfer then doesn't take place within the 3-month window, and the court concludes that in this case that failure to comply with the 3-month period meant that responsibility transferred to Germany. So there was no issue in terms of Article 17 because the responsibility transferred under Dublin because of the failure to comply with the time limit. If you go to page 222, now at paragraph 96, now what the court considered at 96 is whether the Germany have two authorities to whom you can make an asylum application. There's an initial asylum application made to one authority, and then a formal application made to the decision-making German authority. And so the issue considered paragraph 96 was whether a sort of very abbreviated report to the initial asylum authority was sufficient to amount to a claim for asylum, and the court held that it was. But in terms of its reasoning, and in terms of adopting a consistent, objective, rapid process, you can see at the bottom of the page what the court said was this. In contrast, the objective of consistent, objective, rapid processing would be weakened if the starting date for that process depended solely on the choice made by the competent authority, such as the grant of an appointment for a personal interview. And that is a key consideration in this case, because you've got the Dublin III Regulations, which apply across Europe to many different member states with many different approaches to asylum law. And so if the claimant is correct, the appellant is correct, and that any stage in the asylum examination process amounts to a decision under Article 17, then we submit that would totally undermine a consistent, objective, transparent approach, because it would depend on different approaches to looking at asylum claims in different member states. You can see in Germany, when you make the application, you make.
So what you say is the mark of distinction, which determines whether an interview is an examination under Article 17, or it isn't.
Well, we submit that just deciding to interview someone isn't a decision under
To
Article.
examine, an interview to examine somebody, however it's phrased, unless it's expressly said as being in derogation from Article 3.
No, we submit that a decision to examine a claim, as opposed to a decision to take a particular step in the process, is what results in the transfer of responsibility.
Decision to examine the claim.
So, the example I gave in terms of Italy, being there was a period, or there was Hungary actually was a period as well where because of Article 3 you couldn't return people. So then, what the Secretary of State would take the decision to examine the claim. It wouldn't take a decision to issue an invitation to interview.
Okay.
It would decide.
But why wasn't what happened here an examination of the claim?
Well, it was a step in the process, but what it wasn't. The step in the process wasn't undertaken by reference to a decision by the Secretary of State to examine the claim under Article 17. It was simply an invitation to interview and an interview.
So there has to be a decision to examine under Article 17.
Yeah, but not necessarily a formal decision.
But what would I'm just struggling to understand what something that isn't a formal decision to examine under Article 17 would look like, as compared with the letter that was sent to the claimant in this case. What are the necessary requirements for such a decision on your submission?
Well, the necessary requirements are the exercise, evidence of the exercise of discretion for the purposes of Article 17. So, for example, an exercise of discretion that for humanitarian grounds or political grounds or...
Right, but what does the decision need to say in order to provide such evidence?
Well, as I said, my lady, you don't need a formal decision.
No, I know, you keep saying that. Right? What I'm pressing you, so that I can understand it, is for you to explain to me what needs to be in the decision so that it counts for the purposes of Article 17.
But I'm sorry, I'm going to repeat myself, but the Secretary's position is there needs to be evidence, not a decision, evidence that of the exercise of discretion. So, for example, you could have a record in the GSID notes, of the fact that because of the applicant's individual circumstances, maybe they're very ill, maybe they can't get treatment, or.
But how is what's in the GSID notes relevant? Because how does the applicant know what's in the GSID notes unless and until he makes a data subject access request?
Well, because the applicant isn't the applicant's entitled to know and be informed of the fact that he's being dropped out of the process, but he's not entitled to know the reason why he's dropped out of the process. And that's no part of this case. I mean, for example, in this case, when the decision in April 2021 was taken, there isn't an explanation given in that letter for why the decision has been taken to drop the individual out of the process or to remove the individual from the Dublin process. I mean, the Dublin process, mustn't lose sight of it, is although the applicant has rights in terms of the manner in which the process is conducted, primarily it's a process that deals with relations between member states.
Yes, but it also confers rights on applicants. That's one of the innovations in Dublin III.
But there isn't a procedure, my lady, and it's actually referred to in Appellant for informing or requiring applicants to be informed of decisions not to transfer.
Right. So what's missing from the letter that the applicant was sent in June 2016? What needs to be there and isn't there?
Well, had an Article 17 decision been taken, he would have been sent a dropout letter. because the person inviting the applicant, inviting the applicant for an interview, plays no part in the Dublin process. So if there'd been a decision taken for the purposes of the Dublin process, it would have been taken by TCU, and it would have been, the applicant would have been informed as to the fact that the process, he was no longer being considered under the Dublin process by TCU by way of a dropout letter.
So your submission is, unless the Secretary of State sends the applicant a dropout letter, there is no evidence of a derogation under 17.1. Is that your submission? I just want to understand what the submission is.
I think I'd have to accept that if there was a record, for example, in the GSID notes, I would accept. If there's a record in the GSID notes recording the fact that an Article 17 decision has been taken, the fact that it wasn't communicated to an applicant by way of a dropout letter, wouldn't invalidate the exercise of discretion.
All right.
My lady, can I try and put the issue slightly differently? If we just don't focus on Article 17 and just focus on effectively the general approach to Dublin cases, you apply the hierarchy of criteria, and there is always the possibility of the Article 17 discretion. If at the end of that process it is not possible to transfer the individual to another member state, all that happens is that the individual is notified by way of dropout letter, and then the asylum process continues. But when the individual is notified by way of dropout letter, he is not told, well, it's because we didn't comply with the time limits, or it's because Italy didn't accept it, didn't accept the evidence, or any of that. He is simply told, we've done the process, and you are now dropping out of it, we're not transferring you, and the UK will look at your asylum.
All right.
And that's the same, whichever article it's under, that is the approach that's taken.
Right.
Can you just remind me which page the dropout letter in this case is, please? 310.
310.
Thank you very much.
So if I could just then ask you just to go back to page 11 in the bundle, in the authorities bundle.
I'm sorry, where are the authorities model?
Page 11.
That's Article 17.
Yes, my lady. So I just want to make a short point, which we say is consistent with the fact of a deliberate decision or a conscious decision being taken to exercise Article 17, is that the obligation on the state is also to notify and to update, if you look at the third paragraph of Article 1, the fact and the date of when the decision is taken. So again, we say that's inconsistent with an inadvertent decision being taken, since no one in TCU would know that someone in another department has sent out a letter to invite someone for an interview. Can I then ask you to turn to page 12, please? And can I just ask you to look at Article 18 very briefly? These are the obligations of the member state responsible. And as you see, if you just look at the opening words with A, B, C, and D, you have a take charge. And take charge is where someone's made a claim for asylum, but consideration hasn't started. That's this case. It was a take charge request. The other three relate to take-back requests. And the take-back requests relate to cases where the other state has started looking at the case or decided the claim. So when you're looking at the objective under Article 3, under Dublin Reg, for one member state to be responsible for each claim for asylum, considered in the context of any take-back request, where another member state may well have decided the asylum claim already, an interpretation that leads to a second member state having to look at the application is entirely inconsistent with the objective of having only one member state responsible. Because on the appellant's analysis, by sending a letter inviting someone for an interview or conducting an interview, you transfer responsibility to the UK, and the appellant says, well, that's entirely consistent with the objective of having one member state responsible. But that, with respect, is entirely incorrect, because, as you'll see, 3 of the categories of returning an individual relate to where another member state has either taken the decision or is taking the decision. So the appellant's construction of Article 17 is entirely inconsistent with the objective of Dublin III. And indeed, it's actually inconsistent with the whole concept of the Refugee Convention, because if the whole premise of Dublin III, it's on the common European asylum system, the same criteria meant to be applied across Europe. So you've had an asylum claim considered, determined, appeal rights exhausted. Yeah. Why, should another member state then have to look at that claim again? And how does that benefit, or how is that consistent with the objective of the Refugee Convention? It encourages internal movement between member states, which is the whole issue which the Dublin III Regulations meant to deal with. And then again, we're back to the point that a decision not taken for the purposes of Dublin III ends up with a second state having to do what the first state's already done.
Sorry, I expect it's my fault. I'm not quite following that.
Well, if you send an invitation in for an interview, that's enough to transfer responsibility for the decision, so that the UK cannot invite another member state to take back the asylum seeker.
Yeah.
The net result of that is that you have an asylum seeker whose claim for asylum is either being considered by another state or has been decided by another member state, having his claim for asylum considered afresh.
But I'm just not following why that would be so. I mean, take this case. Has the appellant's asylum claim been considered anywhere else?
No, and that's why I said that this case is a take charge.
Yeah. No, I think it's my fault. I'm just really not following this submission.
Where an asylum seeker enters the United Kingdom illegally,
yeah,
he's fingerprinted. The fingerprints are sent back. There's a Eurodac 2, Eurodac 1 match.
Yeah. So there's a hit.
And so the Eurodac 1 match is where there's been where what you're asking them to do is you're asking them to take back an individual on the basis that his asylum claim is being considered or has been decided by the member state who's receiving the request.
Yeah.
And then where the asylum process hasn't yet been started, you then ask them to take charge of the asylum claim. Now, if what is being said is that if the UK makes a take back request, afterwards or at the same time invites an applicant in for an interview, asylum interview,
Yeah.
that has the result of transferring responsibility to the UK. Then the UK will then have to examine that claim in circumstances where it's already been rejected or is being considered by another member state.
But isn't that inherent in the nature of the sovereignty clause?
No, because the sovereignty clause can apply to take charge requests, so where there's been no consideration of the claim for asylum. But it also, we submit, it also applies, this is also an important consideration in whether or not to exercise the sovereignty clause. Because it's clearly one thing to say, right, well, no one started looking at your asylum process, your asylum application. We are, whatever there is about, whatever reason there is for the exercise of discretion on humanitarian grounds, and therefore we're going to assume responsibility for it. On the other hand, a different decision might be reached if the asylum claim has already been determined or rejected.
But that's not these facts.
No, but as an issue of principle, when you're looking at, well, does an act taken in the examination process, does that of itself result in the transfer of Article 17, or does there need to be an exercise of discretion? We say that the objectives of Dublin III are much better achieved or advanced where decisions under Article 3 are taken to require a discretionary exercise of the facts of the case by the Secretary of State. The last paragraph I just wanted to refer you to is information sharing at page 19. And you can see at Article 34 that member states, Article 34.1, can communicate personal data, and then under B, for the purpose of examining the application for international protection. And if you turn over to page 20 and you look at subparagraph G, so that the member states can exchange information on the date in which any previous application for international protection was lodged, the date on which the present application was lodged, the stage reached in the proceedings, and the decision taken. Paragraph 3 then says, furthermore, provided it is necessary for the examination of the application for international protection, the member state responsible may request another member state to let it know on what grounds the applicant bases his or her application, and where applicable, the grounds for any decision taken concerning the applicant. So both these factors in terms of information sharing seem to provide for the exchange of information relating to an asylum claim, and both ways, so that it would be inconsistent with any suggestion that the requesting member state, simply by examining the asylum claim, thereby is responsible for it.
These are all really ancillary to the essential interpretation of Article 17 itself, aren't they?
Well, this is quite an important point because...
Yes, I know.
Because
I wasn't... I want to come back to 17.
No, I am going to...
Just say again how you say 34 helps your... It is 34, is it? Helps your interpretation of 17.
Because 34 provides for effectively for an exchange of information relating to an asylum claim and decisions taken in relation to the asylum claim. And if Dublin III provides for information being shared effectively about decisions taken under both processes, then the fact that the process in the requesting state, i.e. the UK, has started, can't of itself be enough to bring it out of the Dublin III process. Because otherwise there'd be no provision for information relating to the examination process in the UK being provided to another member state, because on the appellant's analysis, as soon as you examine it, take any step, you're out of the process. So if you're entitled, the requesting state is entitled to inform the requested state about the decisions or the stage or the information provided in the course of in relation to the asylum claim, it must mean that the mere fact of taking a step in the examination process isn't enough to transfer the responsibility to the requesting state.
Where's the definition of state that's been requested to take charge or take back? Is that defined? And if not, what is the definition of member state which has been requested to take charge?
The responsible member states defined at Article 18.
Okay. I see, that's as far as that goes.
Yeah. I mean, perhaps if you go to RSM and look at page 329, sorry, because that relates to Article 17, but it's just...
Okay, I want to bring us back to Article 17.
Yep.
What you're saying is Article 17 has, is as it were, a specific discretionary provision.
Yep.
And it involves a decision to derogate, by way of derogation. Yep. And if a case comes into that category, certain things must follow under Article 17. It must inform the member state responsible under the regulation.
To be honest, technically it just has to load it onto the Eurodac provision, but thereby it will inform the responsible member state.
Well, I'm sorry, I'm reading. That's what happens, but
Yep.
its obligation is to inform the member state previously responsible, the member state conducting a procedure for determining the member state responsible, or the member state which has been requested to take charge of or take back the applicant. There's a three situations which may have arisen prior to this decision to examine, and in each case there's an obligation to inform that member state.
No, the obligation. The obligation, my lord, I'm sorry, is to upload the decision on Eurodac.
what it says here is, it shall inform, comma, using the Dublin electronic communicator, comma, the member state, etc. So the obligation is to inform the member state responsible using the Dublin electronic communicator. That's the second paragraph of number 1 of 17.1.
Absolutely, my lord. But that second paragraph that deals with a summary of the obligations, because it's focusing on when there's a request being made to exercise Article 17. But strictly speaking, if you look at the regulations, yeah, and I can take you to the regulations, the obligation is simply to record on the Eurodac system the fact that the United Kingdom has accepted responsibility for the case.
Well, that is the third paragraph of 17.1, which is...
Well, my lord, I'm afraid I apologise.
Well, I'm only going by what the regulation says. And you know, if you're saying to me that I've got it wrong, and of course I'm not surprised that I've got it wrong, because
So
it's much more your specialty than mine. But it does say in the second paragraph there is a duty to inform as certain member states. In the third paragraph, it's the obligation to indicate it in Eurodac.
Yeah. Well, my lord, these decisions are taken. These decisions are taken on occasions without any responsible state having been identified. Yeah. So certainly my understanding of the obligation is that if the obligation is to upload the decision of the Secretary of State on the Eurodac, yeah, and if a member state comes back and says, well, no, I'm responsible, then you would point to the Secretary would point to the Eurodac and say, no, we've accepted the responsibility under.
Okay, well, that may be how it works in practice, but it doesn't really matter in a sense, because all this supports your overall interpretation that this is a discrete scheme for specific derogation, rather than as it were, an automatic process of departure or derogation from the scheme through certain events happening.
Absolutely, because and although
I've not put that very well, but it really comes down on your case, and these other points no doubt supported, but it comes down to how 17 is drafted.
Absolutely, because it's for the purpose of the decision, and then the steps that flow from the purpose from that decision, like for example, notifying the responsible state or updating on the Eurodac, they flow from the fact that you've taken a decision under Article 17. And although I didn't put it very eloquently, that's what I was trying to highlight, where you have a decision to invite someone in for an interview, which has not been taken with any of the Article 17 considerations in mind. It's just simply a process taken in the asylum, from the asylum determination unit, with the sort of decision that Article 17 envisages.
And then 17.2 does this envisage a situation, you may have covered this already, before there's been a decision to examine an application under 17.1, in which an application has been made and the member state is carrying out the process of determining which member state is responsible?
It covers both. It covers the period during which the member state is applying the Dublin process, but also it applies to the position where the responsible member state has been identified.
So paragraph 2 is dealing with a different situation, isn't it?
It is, but what it does say, and this is that it says that the member state can exercise the Article 17.2 power, and prior to any decision on the claim being made.
Yeah.
So if you go to FATI, obviously you have the decision, substantive merits decision taken, and so it's not surprising that it's very difficult to see how the 17.2 power could ever have been exercised, because there had in fact been a decision taken on the asylum claim, a final decision taken in FATI.
On my notes, when you dealt with FATI, we got as far as the AGO.
Yes, that's
I'm
right.
not sure that we got
No,
through.
I'm going to, and
as long as you're going to go back to it.
I'm
it's
going to go
obviously-
back to it now.
I now follow why you're doing that, because you wanted to nail down your points on Article 17 before you went to show why the appellant, you say, is misinterpreting
I did.
the decision, in fact.
I did. Yeah, I did. I don't feel I've done it very eloquently, but I've done my best. If we can go back to FATI then. Now,
Okay.
can I say this? I think FATI is a very, very difficult decision to understand, and so I am going to take it through in some detail, just because I will try and do it.
No. We will finish today.
It is
so you must be as quick as you can.
Was it a third country case at all? I'm looking through. I can see that this Iranian national, the decision was made by the Bulgarian authorities, but was there ever a suggestion that he'd gone through some other country first? I couldn't find that.
Well, again, that's not clear. I mean, I suspect that it's likely that he did to get there, but it's this is what I think. This is what makes the case quite difficult to understand.
Is it all obiter as well, from what you've?
In terms of Article 17, yes.
Because of what? As you
Because it wasn't a question.
Yeah, I mean, but if we look at when we get to the conclusion is by reference to Article 3. Yeah.
Okay.
So the whole thing is about Article 3. It's not about Article 17.
Okay.
So, what have I taken to you?
We got as far as, I think we were on the AGO at paragraph 30, where I've marked myself, there is a dispute between the parties on paragraph 30. Got
Okay.
that far.
So the 30
Of the AG.
of the AG, his conclusion is you need his view is you need a formal decision. Yeah. My point is, simple point, is that the court doesn't consider or address Article 17. Yeah. So there is nothing in the court's decision in relation to Article 17 because it contradict.
Well, what about 53?
That relates to Article 3.
It says.
Oh no, I'll come to 50. But no, is that the paragraph relating to Article 17?
Yes.
Yeah, but if you go 2 or 3 paragraphs up, you'll see that it says we're looking at Article 3 and we need to look at it in context. And then it provides, and then the subsequent paragraphs, yeah, in other words, provided the context to look at Article 3. But what the court doesn't do is say Bulgaria took a step in examining this case and therefore is responsible.
So the reference to Article 17 in the judgment of the court is only, as it were, to illustrate or as part of its reasoning for its interpretation of Article 3.
Absolutely.
Well, should we just look at 51 onwards? Do we need to go further than that? Do we need to go back?
Yes, I was going. Could I just, before we do, would you mind if we just went through a few preceding paragraphs? 154 of the court's judgment.
We're still in the AG, though.
No, we're now in the court's judgment.
Yep.
154. Oh, page 154.
It's the first and second questions then that we're looking
That's
at,
right.
isn't it?
Absolutely.
Yep.
So, now this is important because to understand what the court found. So the first point, is that this is a challenge to trying to use the Dublin procedures to the merits of a substantive decision of asylum. Yeah, so it's a totally different situation here, because what the court was looking at in FATI was if a state has taken a substantive decision, is that decision invalidated because you haven't got a formal decision under Dublin III? The answer was no. But that's a quite different question from what type of decision does a member state have to take in order to be responsible under Dublin III? Can you see?
So it wasn't a transfer case at all. It wasn't, is it A or
No.
B member state that has responsibility? It was member state Bulgaria has made a decision, and the attack was on the basis that that decision hadn't engaged Dublin.
Absolutely, hadn't been preceded by a Dublin decision.
Hadn't
Absolutely.
been preceded by a Dublin decision.
Absolutely. So there's a
Which leaves me a bit foxed because I can't do Dublin unless you have an A state and a B state, and I can't find that in the facts, but that may be my...
Absolutely, but that's why normally in Dublin cases there's an A and B state. But here, the point isn't A or B. The point is, because you didn't do the Dublin and it's mandatory, the criteria and everything, that invalidates the substantive asylum case.
So the applicant was arguing, is this right? The applicant was arguing that the decision which Bulgaria took on his asylum claim was invalid because Bulgaria hadn't considered the Dublin criteria, is that right?
That's right, Dublin process, and hadn't issued a formal decision, an express decision, under Article 3. And the reason why that's so important is because the court was looking at the impact of errors in the Dublin process on the substantive decision. It wasn't looking at what a member state needed to do or not do in order to have responsibility under the Dublin III process. So the point made by my little friend, which I agree with, is that the fact that there's been no Dublin decision doesn't mean that the state can't examine the case and determine it. Absolutely agree with that. But what this case doesn't shed any light on is what the state has to do to assume responsibility.
Can you just say, sorry, can we just... So it does stand as authority for the proposition that a member state can determine a claim
without having issued any decision under Dublin III.
Okay.
But what it doesn't deal with or cover is what a member state has to do in order to assume responsibility for a claim.
Under Dublin.
And then you see, FATI is all about a case where nothing happened under Dublin III. It's not about a case like this, which is what we're arguing about, is, well, what happened under Dublin III? Did the UK assume responsibility? Because in that case, the whole basis of the referral by Bulgaria was that it hadn't exercised discretion under Article 17. In fact, it hadn't considered it at all. Now the next, if you look at paragraph 39
of the judgment,
my lord, I'm going to just deal with the judgment now. You can see that the point I've just said, I think, is made good, because if you look at letter D, no express decision was made pursuant to Article 3 of the Dublin III Regulations establishing the applicant was examined by Bulgaria as the state which the criteria set out in Chapter 3 indicate as being responsible. And if you look at 42, it then highlights the issue the court was considering. And then it's worth just briefly going through 45, 46 and 47. So just for a number of points. One is you will see it's the analysis, as you saw in 42 and 39. Look at 45, it's all about Article 3. And then it refers to the principle being a single member state. Chapter 4 identifies the situations where it may be deemed. And then 46 refers to the requirement to follow the procedures laid down in Chapter 4. So an invitation for an interview has got nothing to do with the procedures or the approach required to be undertaken under Dublin III. And then now 49 is key again. So this is well, if you can read it yourselves, because
I think we should read 40. We've read 51, but I think we should read 49 and 50 to ourselves.
Absolutely, because 49 is a very difficult paragraph to understand.
Okay, well, if it's difficult, you better sit down to give us time to think about it.
Well, sorry, Vic, when I found it difficult.
We now know that Advocate General Mengozzi is a man.
The thing which has been
Bothering
bothering you all day. Right. There's a double negative in the first sentence, which is always confusing.
Oh gosh.
I did say.
Mr. Payne, I advise you to sit down. It's going to take us a minute. There's 3 knots in the first sentence.
Knots.
Yeah.
There's 3 knots in the first sentence. Nowhere apparent from the order of...
The Advocate General is slightly clearer if you want to go back to what he said. What she said. Was it he? What they
Okay. 50 actually goes into 51.
Yep.
So 49 is... Actually, 49 is only about what the court wasn't doing. I think it's, ultimately it's 51 onwards. But it is useful to... You've laid the ground for it, Mr. Payne, I think.
It is, but I do think that 49 is very important, because if I can just try and explain what I understand.
Parse it for us, would you?
Right, I'll do my best. Well, because it refers back to agreeing with the Advocate General Mengozzi, what the Advocate General Mengozzi said, and like what they are saying here, is that they have approached this case on the basis that all the Bulgarian authorities are asking the court to look at is whether you need an express decision. Mm-hmm. And they're approaching that on the basis that the Bulgarian authorities did in fact apply the criteria. Now, if you look at the double negatives, if you unpick it, in the present case, it is in no way apparent from the order that the Bulgarian authorities did not establish that they were competent. So if you strip away the double negatives, the way they're looking at it is that the Bulgarian authorities, they're approaching the question on the basis that the Bulgarians did establish that they were competent on the basis of the criteria, but didn't issue a decision reflecting that. So the question before the court and the analysis of the court proceeds on the basis that, in fact,
they applied the criteria but didn't declare it.
That's right. So the whole analysis here, including the article the 56 conclusion, is on the basis that the state had applied the criteria, just hadn't issued a decision. So it's quite a narrow point, because just looking at the decision.
Yes.
And when you look at 50, then, as to the question whether in circumstances such as those are issued, so those are the circumstances.
It doesn't require you to adopt expressly a decision.
Yeah. And so the rest of the analysis, as is clear from 50, is based on the analysis in 40. In other words, all that the court's looking at is where a state in fact applied the criteria, but there's no express decision recording the outcome of that application. Does that invalidate, or does that preclude a substantive examination of an asylum claim?
Okay.
And they say no, because the criteria have in fact been applied, just no express decision. Then if you look at, in terms of their analysis, 50, they say, it is necessary to take into account not only the wording of Article 3,
but also its context and general scheme.
And so in terms of context and the general scheme, 51 looks at Article 3.
Does not expressly require an express decision.
Yeah, so in other words, if no decision's taken.
Secondly, 52, I'm hurrying you along a bit.
Yep, sorry, big one.
Concerns general principles.
Yep.
And that's the context in which we come to 53, which is where Article 17 is mentioned.
Yep, but again, 53 is again, 51, 2, 3, 4, and 5. They are all, considerations of Article 3 in the wider context. The wider context of Dublin Regulations, the wording of Article 3 and other clauses. And I know that my lady is not keen on this point, but I have to make it in terms of 53. The aim of the option at 53 is to allow each member state to decide in the exercise. And I totally take your point, my lady, that the wording doesn't restrict. It doesn't restrict the factors that could be considered. But what you can take from when you're trying to look at what's the correct approach to Article 17, we would submit it's permissible for you to take into account the aim of Article 17 as being what the court has indicated in Fatty. So I'm not saying that you can't use Article 17 for wider, but the aim of it was what's set out in 53. That was the purpose, and we say that's consistent with a member state needing to exercise a discretion with a view to giving effectively, of the option that it's been provided with. And then if you look at paragraph 54, again, this is part of the wider, the context of the general scheme. If you look at the top of page 157, and this is the point which I think you've all been asking me a little bit about, is, well, what happens when you take a decision to assume responsibility? You don't notify the applicant. And if you read paragraph, certainly the first 6 or 7 lines at the top, you will see that there is no procedural safeguards for someone where the member state accepts responsibility. Yeah. So the requesting state accepts responsibility. There are no procedural safeguards. There's nothing the Dublin III Regulations requires a state to do. And again, the other point to note is in the third sentence, again, this analysis says, as in the case in the main proceedings. So again, this commentary, or this analysis, is by reference to the situation where a member state has, in fact, considered the criteria. And then 55 is another of the sort of the wider contextual points that's made. And then if you look at 56, and as is clear from the second sentence, is about Article 3.1.
Different line.
It seems to me perhaps a genuinely compelling point to make, that if everything was as simple as saying, well, you take any step in examining a claim, you're responsible, all of this analysis would be unnecessary. Yeah, because there's no doubt that Bulgaria intervened. In fact, they took the decision on the asylum claim. So if it was as simple as saying, you take any step at all, you're responsible, that's the answer to this case. And that's not the route the court took. Yeah. Instead, the court looked at it via Article 3 and said, no, you don't need to take a decision under Dublin at all in order to examine a case. And the fact that you examine a case without taking a decision under Dublin doesn't invalidate that case. What it doesn't say is that if you take any particular decision or you take any particular step, you're thereby responsible, because the court wasn't looking at that. And it's consistent with this approach with when I took you to Mengestab and RSM, the fact that in some member states, when you apply for asylum, you get interviewed. So if you're trying to have a consistent or an overall system that applies across the board, you can't have a system where in some states the process means that you can never really use Dublin III because of the fact that you interview them at an early stage, whereas in others you can. So where there's a flexibility being afforded to states to make decisions in individual cases, states should be permitted, we submit, to exercise that discretion in cases they consider to be appropriate, not have that that decision effectively foisted on them in circumstances where they had no intention to exercise their discretion.
But in this case, what happened was, you say by mistake, the authorities did. The asylum unit did assume the responsibility. As a matter of fact,
Well,
they did. They assumed the responsibility.
Well, my lord, we say they didn't, because all they did was to invite someone in for an interview
And they
discuss
interviewed.
their claim.
And they interviewed
Yeah, and they to discuss.
with a view to considering the claim.
Well, if you,
And
then they didn't consider it. They didn't
Well,
consider
it looks from the GSID notes as though some consideration went on.
Well, certainly my interpretation of the GSID notes is that no decision had been
No
taken.
decision? No, I don't think that's suggested, but I can't remember. The passage we were looking at this morning suggests that somebody in the asylum unit was looking at the case
That's
with a
right.
view to making a decision.
Yeah, before the decision. Yeah, before
had they made the decision,
Yeah, that would have been it.
well, what would have been it?
Well, then the had they decided the asylum claim, then the decision would have come out. So the case would have come out of.
That would be it,
The
because
Dublin
he'd
process.
been no longer an applicant
Yeah.
for the purposes of the Dublin
It comes
III
out of the
Regulations.
process.
So there's a narrow dividing line between inviting to interview with a view to deciding the claim here, interviewing, and embarking on consideration of the claim and actually making a decision. So effectively your submission is, unless you make a decision, you haven't exercised your
Discretion under Article
discretion
17.
on Article 17. Okay.
Sorry, a big one. You haven't, by reason of any steps you've taken, exercise your discretion on Article 17.
You never exercise. Your point is, you never get round to exercising your discretion under Article 17.
In this case, in our case, no.
In these circumstances, because once you make the decision, you cease to be an applicant.
Well,
So you drop out of the Dublin altogether.
that's right. So you come absolutely.
You
but
never.
but
if you're under the radar all the time, your claim is considered without reference to Dublin, and it's granted, then you cease to be ever being applicant. So you never come under Dublin.
Absolutely, and I'm afraid the reality is that there are many asylum seekers who apply for asylum, and the issue of whether they might be Dublin III doesn't arise. It doesn't fall to be considered. Where in fact they might potentially be Dublin cases. So there are cases where you just simply person claims asylum, he's interviewed, his claim is determined without any decision being taken under Dublin III because no one knows of the information that might justify a Dublin III process being triggered. But again, without wishing to try the patience of the court, my lady, what you asked me was you sort of focused on the invitation, the interview, the consideration, and the decision, and those are simply actions. And so, the Secretary's position is that until you get to the decision, the mere fact of actions having been taken doesn't, without more, equate to an exercise of discretion under Article 17. However, if either a dropout letter is sent, or there's a record of a decision, a minute of a decision, or there's a record in the GSID notes that it's been decided because of the humanitarian reasons to examine the claim. You don't have to say Article 17 or anything like that, but there's that discretion, recorded. Then that amounts to a transfer. The consequence of that is a transfer of responsibility under Article 17. And what should happen is that even if that decision isn't properly formulated anywhere, there ought to be a date and time when it's been taken, because only in those circumstances can the decision be uploaded onto Eurodac with the necessary information. So whilst I agree that, with my own friend, that the absence of a formal decision doesn't prevent the claim being determined, on the different question, which is where someone is asserting that Article 17 has been exercised, then you do need evidence because that the Secretary has intended to exercise that discretion. My learned friend's point is, well, you don't need a decision in order to look at claim. That's fine. But her argument is different. Her argument is saying you in fact took a decision and we're relying on that decision to say you're responsible. And we say, no, the act of inviting someone for an interview does not reflect a decision in terms of Article 17. And FATI doesn't say that.
If after you, when you would embark, the asylum was embarked upon the process, Italy had belatedly made a decision, what would the consequences have been?
Sorry, if after?
If, as you were in the process of conducting these, you invited the applicant, the claimant, to interview, or even conducted the interview, and at that point after that, Italy had belatedly responded, accepting responsibility, what would on your case, the position would be Italy had responsibility.
Yeah, we can, absolutely.
Whereas on the claimant's case, it wouldn't.
Well,
on the claimant's case, Italy would not have been entitled to claim responsibility or obliged to claim responsibility because from the moment the claimant was invited to interview on the 17th of June.
Well, it's a very difficult concept, when you're used to applying Dublin as to how that could possibly work, because you have the request is being made to another member state. Yeah, the other member state looks at the information, says we're going to accept responsibility, for the decision. As I tried to point out to you, when you look at the various articles, you can have the position where you make an application, or you make a request to another member state. Yeah, you don't have enough information. You then interview someone, and they say, well, actually, I went to Italy, I went to Cremona on this date, so you've got more information. So if you're looking at the objectives, and of Dublin III, why shouldn't you be able to put that information you've obtained, albeit during an asylum interview, back to Italy, and say, well, actually, take him back. You've decided he's claimed for asylum, and then on the basis of that information, Italy accepts it.
Okay. All right. Now, Mr. Payne, I think we've got quite a long way.
No,
what else is there to do?
I just need to deal with, because I'm sure my learned friend will make the point in a usual way, a polite way, but I know she will make it, in terms of the submissions by the Secretary of State, which you've been taken to in the FATI case.
Yes.
So can I just deal with this point?
Okay.
370, please, in the core bundle.
Yep.
So the paragraphs you've been referred to were, so if we start with 22, so the United Kingdom submits, may issue a decision that constitutes an examination. So that phrase constitutes an examination of application. What is being referred to is a decision on the examination. A decision on the application. Because you remember what FATI was considering was whether a decision, an asylum refusal in that case, was invalidated because there'd been no responsibility decision.
Yeah. And
so what the UK was saying is you can issue a decision on asylum claim without having decided, made a decision under Dublin III. If you look at 23, what the UK is saying is it's not necessary for each applicant to receive a notification that a member state has decided to examine the request. And you will recall, I hope, that when I took you to paragraph 56 in FATI, if you remember, the court said Dublin III doesn't provide or set out any procedures for notifying someone of a decision to assume responsibility or to no longer apply Dublin III. So what 23 is saying is that you don't need a formal decision to be served under Article 17 on an applicant. And when I was answering my lady's question, I expressly accepted that if there was evidence that the Secretary had applied her mind and taken an article, a decision for within the discretion of Article 17 or for the purposes of Article 17 or pursuant to Article 17, it was entirely accepted that there was no obligation for that to be recorded in an express decision formal decision notified to the applicant. And then if I could ask you to turn to 372. You have 32, which I think you may have been taken to, but if you haven't, can you just read that, please? And then the last sentence in paragraph 33.
Can we go to the judgment,
Okay.
Mr. Justice Murray?
Yes.
And in particular, where he's analysing your submissions on this at page 73.
Yep.
Is paragraph 54 of the judgment correct? Because that, as I read it, in there he seems to say that Fatih was concerned with Article 3 in a way which you say it wasn't. I'm not sure that's a fatal mistake. In fact, it isn't a fatal mistake. But
Well, I would accept that that's not that's not the Secretary's understanding of Fatih.
Yeah, that isn't, and that's not what you put to him either. I don't think. Reading it earlier on.
No.
So in other words, that's the judge's interpretation, but it doesn't reflect a submission you made. Is that?
That I think is what I'm.
Yeah.
I think that's right. And
so I mean, if you just look back to 49.
yeah, that's where you.
So I said.
Yes, that's it.
In accordance with Fatih, a substantive decision on a right is not invalidated by the absence of a formal decision under Article 17.
No, but you see, the second sentence of 49 isn't right either, is it, on your case? Because you say that in Fatih, it wasn't about Article 17, it was about Article 3.
But I say in the second sentence, I say the defendant's position is that this requires a decision taken pursuant.
No, third sentence.
Okay,
Sorry.
sorry. I think, isn't the third sentence, there is no issue, as there was in Fatih, as to whether a decision on a asylum claim is invalidated by the lack of a decision on Article 17. And I think
I mean, you could delete, in fact, delete under Article 17.
Yes, that's right. It should. Well,
Full stop after the 7.
Yeah, decision under Dublin III. So under Dublin.
Yes,
Dublin.
under Dublin.
Yeah. And if you look at the question, yeah, that's referred to in Fatih. That is the question. And I think I made the same point. Maybe it's not recorded, but I'm pretty sure I made the same point.
Okay. All right.
the Article 17 point, if it was simply enough to say Article 17 was against, that would be it.
Have you said what you want to say on the submissions, UK submissions in FATI?
My lord, yes.
Is there anything else you want to say?
Just very briefly then, in terms of withdrawing the decision.
Yes.
Yeah. One of perhaps the difficulties from the appellant's perspective is that if the appellant is right and you don't actually need any formal decisions, it's just actions, that effectively trigger different responsibilities under the regulations and under the Dublin regulations, then certainly there was no formal Article 17 decision taken in this case.
Yeah.
So there doesn't need to be, we would submit, a formal decision on the appellant's analysis in relation to any other decision to proceed in a different way under the Dublin III Regulations.
Yeah.
So, the whole approach taken by the appellant in relation to the second limb is totally at odds with the approach taken at in terms of the first, because in terms of the first, the appellant says you don't need to take any formal decision. In terms of the second, you say, oh no, you've got to withdraw. You've got to withdraw a decision and refers to the Household Order and Anifru Java. As there being, we've got a formal decision, you need to withdraw that. But if in fact the whole system doesn't require formal decisions, then there's nothing preventing, on the appellant's case, you invite someone in for an interview without having thought about Article 17 or anything, you just invite them in for an interview, and then another member state comes back and says, well, actually, we're responsible. So you simply then accede or respond to that new evidence, that new decision, and pursue the application through to and return it to the responsible state. The fact there are no hard and fast decisions along the way doesn't render the final decision unlawful. Either you've got to have formal decisions, and then when they are formal decisions, you've then got to have formal decisions withdrawing them, or you don't have to have any formal decisions. And in that case, you're just looking at the way the process proceeded, and you have someone who says, right, well, I'm going to invite someone in for an interview, and then you've got someone else saying later on, well, actually, Italy are responsible, and we're going to proceed with return. And the last point I wanted to just touch on very briefly is that there is actually a formal Article 17 decision in this case, and that is to say that Article 17 doesn't apply. And if you turn to page 296, just so you know, it's just so you've got the date, so it's 10th of November 2016.
Yep.
And then if you turn to 308,
yep,
and you look at the bottom, you should have a heading Article 17. 308, my lady.
308, thank you. But is this a response to later submissions?
It is, yeah.
Right, so this post-dates the material on which the appellant relies in support of a submission that there had earlier been an Article 17 exercise of discretion in his favour.
Absolutely, because because there's no. Yeah. But insofar as it's suggested that the applicant doesn't know why Article 17 isn't considered applicable, the applicant does know, or the appellant does know, because it's set out in terms of in that letter.
Right.
My Lord, if unless there's anything else I can assist you with.
Thank you very much, Mr. Payne. Ms. Hewitt.
Lord. I'll start at the end and I'll try and then arrange these submissions in some kind of order. Firstly, just to deal with the point that's just raised in relation to the Article 17 decision in the letter of the 10th of November. That letter of the 10th of November is a response to a pre-action letter. That pre-action letter is found on page 293, and what was actually said in that letter is there has been a de facto decision to examine the application for protection under Article 17, which caused the UK to become the member state responsible. So it wasn't an application asking the Secretary of State to exercise discretion. It was a legal submission that, as a consequence of the decision to interview him in the UK, that discretion had been exercised and responsibility had transferred. The other thing that I want to make absolutely sure I deal with is FATI, and if we could just turn to
The decision
123.
123.
123. This sets out the questions that the court was considering.
This is in the Advocate General's.
This is on page 5. It's in the Advocate General.
Yes.
These are the questions that were referred to the court. Question 1. Does it follow from Article 3.1 of the Dublin III Regulations interpreted in conjunction with Recital 12 and Article 17 of that regulation that a member state may issue a decision that constitutes an examination of an application? I'll leave you to read the rest. If in the particular case there's nothing to give rise to a derogation pursuant to Article 17 of that regulation. So the nice attempt to say that this was all about Article 3 and nothing to do with Article 17 in my submission is just wrong. There's a very clear question, which is Article 3 plus Article 17, does it require evidence of derogation that was determined by the court? And the reason for that is that, as I hope was clear in my earlier submissions, this is a complete code. There is no procedure outside of Dublin unless the Article 17 derogation is implemented. Any examination of a claim otherwise is within Dublin because you are the member state responsible. So this idea that there's some sort of parallel process that can be entered into is just wrong. And it's on that basis that we have one state responsible for examining the claim, not making a decision on the claim or exercising their discretion to examine the claim, then changing their mind, which is okay as long as you haven't made a decision, but not okay if you have made a decision. It's that there's one state responsible for the examination of the claim, and that's determined by the hierarchy criteria, unless you apply the derogation that you're entitled to under Article 17 and accept responsibility for a claim that you're not otherwise responsible for. And it is my submission that's what's happened in this case. At one point it was suggested that this submission would be contrary to the Refugee Convention, and this appellant is not saying that there is an obligation on a state to accept responsibility for a claim it's not responsible for. All that he is saying is that once you have examined his claim, you are the member state responsible. That's not contrary to the Refugee Convention. Any problems with that are dealt with by member states not accepting responsibility for claims that they're not responsible for. It was also suggested that it wasn't the appellant's position that the decision to invite him for interview was anything other than a decision to interview. Again, that's just wrong. And you can see that in the original pleadings at page 100. It's always been that the Secretary of State had decided to examine the claim in the United Kingdom. I think you have the points in relation to it matters not which part of the Secretary of State made a decision.
Yeah.
If they were entitled to make decisions, they were entitled to make decisions. And running through the Secretary of State's submissions is this stress on the fact that it's something to do, has to be done by the third country unit, and that's just not a proposition in law that can be sustained. It's not only not in the regulation itself, it's not in domestic rules or laws, and it's contrary to the established case law of the CJEU. The asylum claim itself was not refused by the UK. What happened was the UK declined to consider it, and you'll see that at pages 344 to 346, which is the decision. The decision of the 6th of September states acceptance by default from Italy, a decision's been made to transfer. There's a difference between transfer and removal that has never really been made clear in Dublin cases. Under Dublin, it's a transfer. When an asylum claim is refused, it's a removal. And then the certification decision, which is on the following page, page 345, it says, you are returnable to Italy. The Secretary of State will normally decline to examine the asylum application substantively if there is a safe third country to which the applicant can be sent. There are no grounds from departing from that in this case. And I should say this does actually say there's a removal decision as opposed to a transfer decision, but it is technically a transfer under the regulation. And so it's not a refusal. It doesn't bring with it all of those problems that the Secretary of State said would occur if an asylum claim was refused in the UK and then transferred. The Article 34 of Dublin on information sharing doesn't create the problems contended for by the Secretary of State. There are circumstances where an application can start to be examined, but transfer can take place prior to a first decision. And you see those in Article 17.2, you see them, I think, in Article 8. They're set out in my skeleton argument that there are very specific exceptions where a member state can start the process of examining a claim, but when it becomes not the responsible member state, or when it becomes apparent that another member state is responsible, it gets transferred. Not just that, but in terms of recording the process of the claim, or the stage at which it has been reached in the information sharing system, that's important for when a state puts in a set of fingerprints to see whether they're making a take-back request or a take-charge request. And if that take-charge request is in respect of somebody whose claim is under examination, has been determined, or has been withdrawn. So it's not in any way something that undermines what the appellant says about Article 17. The fundamental point is that the wording of Article 17 is clear on its face. It's examination of a claim. That's what was also determined in FATI, examination of a claim, not decision. It could have been decision. Decision is one of the words used in the definition, but it's not. And in terms of what is actually said in FATI, which I would like to go back to at 49 and 50, the appellant completely rejects the interpretation that's put on this by the Secretary of State. What the court actually says is not there was evidence that Bulgaria had examined the case under the Dublin criteria and reached a decision, but that it was not apparent that they had not. And these two things are quite different.
Yes.
And then at paragraph 50, the question whether in the circumstances such as those at issues in the main proceedings, and this is the interpretation of Article 3 and Article 17 taken together at 51, 52, 53, through to 56. And so it's wholly incorrect to say that this has no bearing on the interrelationship, in particular, between Article 3 and Article 17, and whether or not an express decision is required under Article 17 to make lawful something that otherwise would be unlawful under Article 3. So effectively what the CJEU said was that under Article 3 they might have been responsible, but even if they weren't, it was saved by Article 17, and there's no requirement for an express decision under Article 17. And the real difficulty, which I think is probably my final submission, is that if you say that a decision is required under Article 17, that's contrary to FATI. Because FATI says there's no procedural requirement, no procedural step, and no decision is required. And that's a decision under Article 17. If you find that Article 17 has been implemented, or the derogation from Article 3 exists under Article 17 in a case where a decision has been reached, then the wording of Article 17 requires that to be the case for any case where there has been an examination of the claim. An examination of the claim is defined in Article 2 and is accepted to have happened in this case. The only, and I apologise, I should have dealt with this in my submissions. The only other thing I wanted to draw the court's attention to, just in case it becomes relevant at any point, is is paragraph 51 of the case of ZN Afghanistan. It may not become relevant.
ZN
Afghanistan.
51. Okay.
And again, bearing in mind this was a costs decision, and the whole point of whether or not a claim is academic is so as not to take up the court's time with that claim. Sorry, it's paragraph 51.
Are you talking about the cost of this hearing?
I'm talking about the cost of this hearing, and in the court below to a degree. At paragraph 52.
Well, there's no cost. There's no offer cost below.
No, there is an appeal against that cost,
Yes.
which is linked to this. We have a permission application linked to this hearing.
Okay. Okay. Well, for my part, I noticed that.
I just,
Super.
all I say at this point is that at paragraph 52 says in cases where there's been some compromise and the compromise does not actually reflect the claimant's claims, there's an even stronger case for there to be no order as to costs. This is mitigated by the proviso that there will be some cases in which it may be sensible to consider the underlying claims and consider whether it was tolerably clear who would have won if the matter had not settled.
So that's
52 actually.
Eamon Croydon and Lord Justice, the judgment of Lord Justice Newberg, was it then was?
That's right, and it is my submission that this is a case where it's been clear from the outset that Article 17 says if you examine the claim, you're responsible for it, and that's it. Those are my submissions, unless.
Thank you very much. Well, we're very grateful to both of you for your submissions in this case. Obviously, we're going to take time to reflect on what you've said. We'll reserve judgment. I think it's unlikely that judgment will be handed down this term. We've only got a few, about 8 or 9 days to go. In due course, you'll be getting the judgments in draft in the usual way. Typographical correction. Please bear in mind the embargo at the top. When we've had your corrections back, then judgment will at some point be handed down under the new scheme. That's an automatic process that happens remotely, no need for any attendance. You'll be asked to prepare an order in the light of our judgments. If there are any ancillary issues which require to be resolved on that order, they will be determined on paper.
My Lord, just one question in relation to that, given that there is a permission application in respect of the costs. I think our view was that was better left to be dealt with until after the appeal.
Cost, yeah. Yes,
well,
yes.
or dealt with as part of the judgment.
Dealt with as
Yeah.
part of.
Well, do you want to say anything else? We don't know.
No, I don't think so.
All right.
Deal with as part of the
At the very least, I would just seek permission on that, irrespective of the
Yes,
outcome of that.
so you need permission to argue that.
Yeah. Okay.
But effectively, we've heard the arguments.
Thank you very much.
Thank you.
Thank you. Good afternoon.
Board line.